Get your game face on. Just kidding.
Yeah.
Anthony,
Exactly.
how are you doing? You're doing okay?
Doing okay. Yeah. Today was supposed to be our feast day at Santo Domingo, but everyone's just kind of cooking the feast foods at home and
Yeah.
doing all that good stuff. So yeah, we're gonna
The
have
the Jemez Pueblo did the same thing. That they.
yes, the day before yesterday, they have their Pecos feast.
Someday I'd like to participate in one of those. You know, that would be wonderful. That they're,
Me too. That's one thing I've never gotten to do in all the years I've been in New Mexico.
Oh yes,
Me first.
definitely. When you know, if you have the chance, definitely come and then just ask for the people you know, and then they'll lead you to their house, and then they'll tell you to sit down and eat. There's lots of food.
That's wonderful. That's wonderful. Well, we're up to 115 people. Boom.
Yep, I'll wait a couple more minutes and then I'll launch into my quick announcements and hand it over to you, Jeff.
Okay, thank you. Thank you, Rachel.
Yep.
When we start, this will directly go on this PowerPoint. Nothing more I need to do.
Yeah,
just
you can,
advance
if you
the
want to.
slides.
Yep. Everything that you see is what the audience sees, David. So if you want to double check and advance the slides one more time to just make sure either your mouse
Okay.
or your arrow keys are working.
Yep.
Cool. There we go. Yep, that's all you'll need to do.
Okay. Great. Okay.
I'll give it one more minute. We're at 1:40, so.
Yeah, David, when after I do the introduction, I'm going to blank myself out too. So this is your show. The only reason they want me on it is they couldn't credential you quickly enough. So you're piggybacking on my credential here.
Oh, that's
or,
fine.
or I'm abusing your friendship, one or the other.
That will never happen.
Okay, so people are still joining, but I'll just get some of these announcements over with. Good morning, good afternoon, everybody. Thank you for joining. My name is Rachel Hasna, and I'm with UNM's Division for Community Behavioral Health. Welcome to our Law and Mental Health Didactic. A couple of housekeeping announcements. So if you stay with us for the full hour, Anthony will be posting the evaluation link to receive a certificate from APA or the New Mexico Counseling Therapy Board, or a certificate of completion. He'll be posting that eval in the chat towards the end of the presentation. You'll click on the link or copy and paste it, and you'll fill out the evaluation, and a certificate is automatically generated for you. It is your responsibility to save it. So if you're on your smartphone, you'll want to do a screenshot of the document. If you're on your laptop or your computer, you'll want to just save the document on your desktop. Again, the evaluation will be put in the chat. If you're calling in, feel free to send us an email and we can get the evaluation link to you via email. The PowerPoint slides will be emailed out later on this week. Folks always ask about that, and I think that's pretty much it. So I'm going to hand it over to Jeff.
Well, it's a real pleasure to have one of my good friends as a speaker. And before I introduce him, I want to remind everyone of the presentation we have scheduled for next week at the University of New Mexico, which is entitled Law and Mental Health Ethical. Oh, that's David's talk. I've got too many sheets of paper here. Law and Mental Health, the role of the forensic psychologist in a criminal courtroom, perspectives from a federal judge. And it's going to be featuring the Honorable Martha Vasquez, who is the judge of the U.S. District Court for the District of New Mexico. It's going to be a very exciting presentation, and we hope you all will join us for that, as well as the one that we're going to have today, which is, it's a real pleasure to introduce one of my very good friends, actually. I've known David Shapiro for, I think, 30 years. We worked together on the APA Ethics Committee. We've written together, and I have nothing but the highest respect for David, who many of you have read his books and his articles, and productive in scholarship in forensic psychology. He's currently a professor at Nova Southeastern, and is an ABEP in forensic, actually one of the original ABEPs of forensic. I know that he looks like he's about 28 years old, but he is older than that, and is one of the founding members of the forensic board. So it's a real pleasure for me to introduce to you my good friend, David Shapiro.
Well, thank you, Jeff. I assume I'm on now. I'm delighted to have this opportunity to talk to you. I was mentioning to Jeff and Rachel before we got started that this is a huge area, so I can only touch some of the highlights in the next hour. So let me jump right in, and hopefully you will have questions which you can bring up at the end. We will have a question and answer session. So first, let's look at some of the similarities between clinical and forensic work. Both of them use a broad range of assessment techniques. We use testing, we use clinical interview, we use history taking. We use, in forensic work, a lot of what we call collateral sources, interviewing with family, friends. In the criminal work, we're interviewing police officers, witnesses to various crimes. We're talking to employers, we're talking to teachers. So what you do is you get a large database, and then what you're trying to do is to integrate the data. This is one of the things that is important in clinical work, but even more important in forensic work, is the integration of data across multiple sources, looking for consistencies and inconsistencies. One of the things we'll talk about is not ignoring the inconsistencies. There is a tendency, I'm sure you've all heard about it, called hindsight bias. When you start off with a particular hypothesis, I believe Dr. Otto even talked about this a few weeks ago, a tendency to just either wittingly or unwittingly screen out data that is not supportive to your initial hypothesis, and to include only the stuff that is consistent with. You've got to make sure you don't do that. That involves several ethical standards as well. And then you are writing a comprehensive report addressed to the referral question, okay? Sometimes reports go on and on and on. And I've had lawyers say to me, what is all this stuff? It's all very interesting, but it doesn't help me with the case. So the report should reflect back on the referral question. Okay, now, what are some differences? Obviously, one of the major differences is the focus of the evaluations. In clinical, you are looking to help make a diagnosis, to make treatment recommendations, to look at prognosis. Now, you have those in forensic work also, but there are also some very important legal issues that you need to be concerned with and need to look at quite differently from straight clinical work. Informed consent, for instance, is very important in just about any clinical context. You you have, and that has been detailed in other workshops, namely talking about what the nature of the contact will be, who you are, who it is that retained you, what the nature of the evaluation will be, how you're going to be going about it, and the most importantly has to do with limits of confidentiality. In other words, who will get the report that that you are providing. Now, all of this up to this point is true both for clinical and for forensic work. However, forensic work has an additional wrinkle because in terms of the material that is disclosed and to whom, we have an additional concept, which is called privilege. There is, for the most part, in clinical work, what we call psychotherapist patient privilege. In forensic work, we have, in addition, the concept of attorney-client privilege. Now, when you are hired by an attorney, at least a defense attorney, this would not go for the state, but if you're hired by a defense attorney, your work is covered under what is called attorney-client privilege. Your work is what is called work product. It is protected under that attorney-client privilege. Now, let's say you have done an evaluation and that evaluation comes out to be unhelpful to the defense attorney who hired you. Obviously, that defense attorney doesn't want that report that is not helpful to come into court. So what they can do is, under the attorney-client privilege, they can basically just bury that report. No one has to know that you ever saw that individual, just the attorney of record and the person that you have examined. And in theory, that defense attorney can go out and hire a second, a third, a fourth expert until they achieve the result that they wanted. Okay, and in most states, with the exception of a handful, that's where it ends. No one will ever know that you did that evaluation. Say the lawyer is trying to assert an insanity defense, and you say to the lawyer, I'm sorry, I think your guy is malingering. Okay, no one will ever know that you found out that your assessment revealed the fact that he or she was malingering. However, in a handful of states, last time I counted, it was about 8 states, they have a more open discovery where if a lawyer is asserting a particular defense that includes some sort of mental health issue, the opposing side, that is the state, can say, okay, now, did you ever hire any experts who came to an opinion that you're not using? And the defense in those states has to reveal the name of a non-testifying expert witness. And then the state can go ahead and hire you. So while you were initially hired by the defense, you may wind up in court testifying for the state. So it's very complex. You have to understand which law applies in the state in which you are practicing, where the attorney-client privilege covers you, and the extent to which your opinion may be revealed to the other side. Okay, so this is one of the major kinds of differences. You need to integrate your clinical and your forensic findings. A clinical diagnosis is not the same as a legal conclusion. we come across the concept of functional legal capabilities or capacities. I think the first time that this was presented was by forensic psychologist Thomas Grisso back in, I think it was 1988, when his book called Evaluating Competencies came out. And in an introduction, Grisso raised the question, why are our reports so often ignored by courts? Why are they seen as irrelevant? And the answer he comes up with is that we focus on the clinical data, and we have assumed that the clinical data is essentially equivalent to the legal conclusion, such as, and these are actual statements I've seen in forensic reports. This person is schizophrenic and for that reason is incompetent to stand trial. Or this person has frontal lobe dysfunction and for that reason could not appreciate the wrongfulness of his behavior at the time of the crime. Okay, you're seeing the diagnosis is being lifted and made into the legal conclusion. That is improper. What you need to do is to look at the functional legal capability underlying each. So for instance, competency to stand trial is broken down into 3 categories according to the law: having a factual understanding, a rational understanding, and an ability to assist counsel, assist one's attorney with a reasonable degree of rational understanding. So to take the example I gave before, it would not be proper to say he is incompetent because he's schizophrenic. Rather, to say his schizophrenia is manifested by the following symptoms, A, B, and C. And the symptoms would affect his factual understanding of the proceedings in the following manner. The symptoms, say, of concrete thinking would interfere with his or her ability to have a rational understanding. His experiencing hallucinations would interfere with his ability to concentrate on matters in court and therefore could impact on his ability to assist counsel. So this is how you use the clinical and the forensic material together. Do not overgeneralize from one to the other. Okay, now let's look a little bit at psychological testing in a forensic setting. We have some problems that we really need to pay attention to. One having to do with test validation, and really the conceptual issues they interface with the validity issues. Okay, we basically are supposed to use psychological tests only for their intended use and only to answer questions that they were intended to answer, and that the answers are applicable to the population on which they were validated. So for instance, if a test is validated, say on people who are undergoing psychotherapy, the conclusions from that, the interpretations from that data should be restricted to people undergoing psychotherapy. If you are using using this assessment instrument on a different group, then you have to show how you extrapolate from the validation group to the group on which you are using it. I've come back with some examples of that in a moment. Projective techniques. You will find some people who say, oh, you would never use a projective test in a forensic setting. Well, I happen to disagree with that. I teach courses, have taught courses in projective testing for many, many years. Perhaps in its very early years, where it really did not have any objective data to support it, that might have been an accurate statement. There has been, perhaps in the past 40 to 50 years, a huge amount of research, specifically with the Rorschach, unfortunately, not with other projective techniques. That does not make it so totally subjective, that you can make certain kinds of statements based on your projective test data. Once again, subject to the constraint mentioned before, which is the forensic constraint of it is only one among multiple data points which you are trying to integrate. So you don't generalize from one test or even one response to a conclusion. You want to integrate into these, the test validation in terms of forensic conclusion, what is the real world data? So let's say you have a person to whom you are administering a Wechsler test, a Wechsler Adult Intelligence Scale. And the question has to do with their competency to waive, to forego their Miranda rights. Well, what you do not want to say is that the person has an IQ of, say, 65, and for that reason is not capable of understanding their Miranda rights. I even heard one psychologist testify in court. He described himself as a psycholinguist, and he had analyzed the reading level of the Miranda warnings in that particular jurisdiction, which was an 8th grade reading level. He testified that since this person had a 4th grade reading level, by definition, he was not capable of understanding his Miranda rights. Again, that's improper because the testing has no way of incorporating how many people he's talked to, how many times he has had, say, contacts with other inmates, contacts with an attorney, before he actually takes that test. Okay, assessment of trauma has become a very, very important area in a lot of forensic assessments, as has the assessment of malingering. Any forensic assessment that fails to deal with either or both of these is probably going to be inadequate. You will get certain tests which are computerized, and these computer printouts, they say right on the printout, they need to be integrated with other data. Once again, the consistency across data sources. Now here's the normative data. And I give you some examples perhaps on the Milan. That's the MCMI, currently MCMI-4, and the MMPI-2, though I realize that that is supposed to be surpassed now by the MMPI-3, which is apparently coming out shortly. But as an example, the Milan has in its test manual and in its computer printout a statement to the effect, this test has been normed or validated in a population of individuals in the early stages of psychotherapy. Any use of this test for any other purpose would be professionally inappropriate. Words to that effect, okay? The Milan happens to be one of the most frequently used tests in child custody evaluations. That is inappropriate. It has never been validated in a child custody population. If you were to use the Milan, number one, it would be within that, what is it consistent with framework, and number two, how you extrapolate from a population consisting of people in the early stages of psychotherapy to people undergoing a child custody evaluation. Similar kind of thing with the MMPI or the MMPI-2, the restructured form, the RF. And that is, surprisingly enough, and this will probably surprise a lot of people, the MMPI-2 has never been validated in a pretrial forensic population, the population which you will most likely be doing your forensic evaluations in. It is, it's got a lot of clinical data, various clinical settings. There is even one of the validation studies that was done within a prison setting many years ago by Edward McGargy. But that is not the same as a pretrial forensic population. The items may have very, very different meanings. And this is in a forensic population as opposed to a clinical population. These somehow need to be accounted for in your interpretation. The idea of doing a blind interpretation of the MMPI in a forensic setting is inappropriate. So, for instance, items such as there are people who can control my movements. Well, in a clinical population, that sounds like it's a really serious kind of paranoid delusion. But when I've gone back and asked inmates about it, they say, oh, sure, the correctional officers tell me when to go into my cell and when to come out of my cell. So there's nothing psychotic about that. It's just the reality of the environment in which they're living. Let's say the item people say vulgar and insulting things about me. Well, you get yourself into the middle of a child custody battle. Yes, the attorneys do say vulgar and insulting things about you in court. Let's say you're doing a personal injury evaluation and the person says, true to the item, there are people following me. Well, it may not necessarily reflect paranoia. It may reflect the fact that in many personal injury cases, one of the person who's being sued, the defendant, will hire, the lawyers will hire a private investigator to follow that person. So you cannot interpret these items separate from the context in which they were generated. The ethics code talks generally about needing to take context into account. The forensic specialty guidelines are much more specific. They go on to say that exactly the same items may have different meanings within forensic as opposed to clinical settings. So be very, very careful about how you use these tests, and how you extrapolate the data. Let's see, oh, yes, the one test that I do know, the one personality test that I do know that in fact has validation data from forensic settings is the PAI. The Personality Assessment Inventory has done normative studies within both jail and prison populations. And for those of you familiar with the PAI, you notice rather than having one cutoff point that on the MMPI-2, I think is a T-score of 65, you have on the PAI cut scores, sometimes called a skyline, that is different depending on the population from which the client comes. Okay. Now, what we've been talking about thus far is the traditional clinical assessments being used in forensic settings. However, we have a whole new generation of tests, probably within the past 25 to 30 years, where they are called forensic assessment instruments. Here, the legal issue itself contributes to the test. In other words, the test is formulated around the legal construct. It should be used in conjunction with clinical tests. Let's give an example, for instance. There's a very comprehensive test for competency to stand trial, structured interview. It's called the MacArthur Competency Assessment Tool for Criminal Adjudication. Fairly lengthy, but gives you a very good comprehensive overview and addresses issues of competency from 3 different legal points of view. So you get a pretty good sense, along with the rest of your clinical interview, of course, about how, whether or not this person meets criteria for competency to stand trial. However, if they do not, it doesn't tell you the why. It doesn't tell you why they can't meet the criteria. So that's why you need the traditional psychological tests. Help answer the why. You know, is it due to a thought disorder? Is it due to intellectual disability? You know, whatever. Another one, the same Dr. Thomas Grisso that I mentioned before, has a very extensive series of instruments dealing with appreciation of Miranda rights. And once again, if you come up with someone who genuinely seems to have difficulty understanding their Miranda rights, what is it for? What does it do to? And that's where your more traditional psychological testing comes in. You know, helps give you an idea about what may be contributing to it. Now, admissibility of expert testimony is very interesting here. I don't want to spend a lot of time talking about different tests for admissibility, except to say a lot of states have utilized an old standard called the Frye standard, F-R-Y-E, is that the methodology, the theories have to be relied upon by, are generally accepted by the relevant scientific discipline. Okay, there are problems with it, which we won't discuss here, have to do with how do you define general acceptance, how do you define relevant scientific discipline, but it is seen as a general admissibility test. So again, to take the issue of competency, do most people who do competency evaluations, most mental health professionals, would they find this test or theory or methodology acceptable? Okay, that was supplanted or at least added to. That was a test way back from 1923. Several states later adopted an evidence code from federal law called the Federal Rules of Evidence. The Federal Rules of Evidence basically, while they didn't, discard Fry, they incorporated it into a broader test, which had to do with assistance to the trier of fact. Was someone qualified as an expert? First, they had to be qualified as an expert. Secondly, they would be testifying about something within a scientific, technical, or general knowledge that was out of the knowledge base, out of the realm of the ordinary lay person. In other words, it's something that a judge or jury would not ordinarily do. Then an expert is allowed to give an opinion, provided that opinion is generally accepted by the relevant scientific community. So the Fry gets incorporated into a much broader standard. We then have a standard called Daubert, came about in 1993, which addressed the issue of what does it mean reasonably relied upon by other experts in the same field. And it gives a series of criteria, sometimes called the Daubert 4 factors. A misunderstanding is just how far these 4 factors go, because a lot of clinically oriented testimony would not make it into court under those 4 factors. A testable hypothesis and a known error rate, things of that sort that might be applicable to purely scientific testimony, but not applicable to more clinically oriented testimony. And then finally, there was a case from 1999 called Kumho, which suggests that those Daubert factors are advisory, they are guidance, they are not what Justice Breyer called dispositive. In other words, scientific testimony may well be judged by those, but other ways of dealing with general acceptability may apply to other kinds of testimony. So, what these forensic assessment instruments, how are they generally dealt with in court? For the most part, they have been accepted, though I will say this is much more recently. For instance, the MacArthur test was published, the competency test was published back in 1997, I believe. And around 2001, I was testifying in a competency hearing, and I wanted to testify about the results of that assessment instrument. And there was an objection from the state saying, and the state at that time, this was the state of Florida, was under the Fry standard. And they objected and stated that the MacArthur was not generally accepted by other psychologists, which was probably true when you took psychologies as a whole. Psychologists familiar with forensic work, it might have met it. However, it would clearly meet Daubert because Daubert talked about the qualified expert using methodology, and it would probably even meet those scientific 4 factors. So the short answer to the question is it depends, although most of these tests have now been accepted in a variety of courts. Okay, now a few, going back to the APA Code of Ethics, let me talk about, again, there are many, many different things in it that are important. I'm going to try to focus on some that, I think are most important. First of all, limits of confidentiality. Of interest is that this section of the Ethics Code did not even appear until the 1981 Code. Prior to that time, there was just a statement, about the importance of confidentiality, but nobody even talked about limits of confidentiality. In the mid-1970s, we get a case from the state of California called Tarasoff versus Regents of the University of California, dealing with what a therapist needs to do if one of their patients or clients makes a credible threat of violence toward a third party. And again, the case itself is very complex. There were actually 2 separate cases by the name Tarasoff, but ultimately it turned around to be what was called a duty to protect, rather than, and the original case was a duty to warn. At any rate, it did raise the point that in certain circumstances, you could not maintain absolute confidentiality in psychotherapy. And that has remained in the Code of Ethics ever since it was first addressed in 1981. When we come to 1992, come to an interesting development in the Code of Ethics, which is prior to this time, up to 1992, we had what were called aspirational principles and enforceable standards all mixed together. So the aspirational principle, for instance, psychologists do not engage in any activity that would violate the civil rights of their clients. Psychologists maintain the highest standards of the profession. As opposed to enforceable standards, you don't have sex with a patient, you have to have sufficient training before you undertake a particular task. So 1992, for the first time, they separated the 2 of these. What had been happening, by the way, is that people were being sanctioned for violation of some of these aspirational principles. And they would basically say to APA, well, you say I'm in violation because I haven't maintained the highest standards of the profession. Tell me, APA, what are the highest standards of the profession? APA was unable to respond to that. I'm fond of saying it's sort of like pornography, you can't define it, but you know it when you see it. So APA is basically saying, well, we can't define the highest standards of the profession, but we know you didn't reach them. That was just too wishy-washy to be accepted in a court of law. So it moved from these things being together to being separated, and only a violation of the enforceable standards could result in a sanction from an ethics committee. Interesting, in the 1992 Ethics Code, there was a separate section called forensic activities. which came about largely as a result of recognition that some things that were going on in forensic settings were not adequately covered by the Code of Ethics as it existed at that point in time. I think it was a very, very helpful and valuable part of the code. But in 2002, when the next code came into existence, the forensic activity section was removed. Honestly, I don't know why. Some of the issues, such as the need for extensive documentation, specifically stating level of documentation in forensic cases is expected to be higher than the normative level of documentation in clinical work. That was just taken out, and it was basically reincorporated into the 2002 code as everything should be well documented. The idea of knowing the laws that impact on what you are doing, that was originally in the forensic section. It was taken out and put into the competence section. The very definition of competence basically followed the federal rules of evidence regarding the admissibility of expert testimony. Now, some people started using the code by itself as what was called a standard of care. In other words, saying that anybody who did not follow everything in that ethics code, word for word, was by definition negligent, say in a malpractice case or in a licensing board investigation. It was made clear, and in fact, in the 2002 document specifically said that standard of care is a much more complex legal concept, and the ethics code in and of itself does not constitute the standard of care. Another point very important in the ethics code section about avoiding harm, taking reasonable steps to avoid harming those, not only our patients, but those with whom we work. Okay, now most people would not set out to deliberately harm those with whom we work. However, there are more subtle issues which sometimes psychologists really don't think through. I want to give two examples. One is in those states that have capital punishment, some people do competency for execution evaluations because Supreme Court ruled back in 1986 that you cannot execute people who are insane. And that came to be interpreted as meaning, do they understand the reasons that they are being executed? And by the way, I'm just putting out some statements. I don't want to be regarded as being critical of anybody who does these, just that these are issues that should be thought about. Let's say you do this evaluation, you find that a person is competent to be executed. Can you then say, if the person goes ahead and is executed, can you separate yourself from that? Can you separate that from taking reasonable steps to avoid harm? If you say, well, I helped them get some treatment, I found them incompetent to be, well, that's, but then they are treated, most often medicated, sometimes against their will, in order to make them competent for execution. So these are things that need to be thought about. Those of you who do sexually violent predator evaluations, again, some disturbing questions come up for me from an ethical point of view. First of all, the definition of a sexually violent predator: it's an individual who suffers from a mental abnormality or personality disorder that predisposes them to commit predatory acts of sexual violence. Well, first of all, there is no such thing as a mental abnormality, let alone a mental abnormality that causes predatory violent sexual behavior. We are making a prediction there that based on this condition, the person will act out in the future sexually violently. The research on prediction of sexual violence is very, very poor, even worse than the research literature on predicting violence in general. What happens if you say that somebody is a sexually violent predator? Well, they're involuntarily committed for treatment. There is no validated treatment, no evidence-based treatment that is effective with this population. And finally, the law allows individuals to do one of these sexually violent predator evaluations without seeing the person. You know, they can base it on a review of the person's chart, which violates a very definite principle, ethical standard of not making diagnostic conclusions about people that you haven't examined. Okay, word or two about multiple relationships in forensic practice. First, in general, you try to avoid multiple relationships because they can have the potential for harm. They're not per se unethical, although some people will tell you that they are, but they're not. But if they are likely to cause harm, result in exploitation, result in loss of effectiveness or loss of objectivity, they should be avoided. Why in a forensic setting do you not want to mix forensic with clinical, with therapeutic roles? Number one, the relationship is different. As a therapist, you are in a therapeutic alliance with that individual. Forensic work is based on an objective, impartial evaluation. As a result of that difference, the methodology is different. In psychotherapy, you are basically accepting the patient and their concerns where they are, you know, where they are psychologically. In forensic practice, you are supplementing your clinical opinions with lots of collateral data, doing extensive psychological testing, which may involve, usually does involve, an assessment for malingering. So you can see how you do not want to do an assessment for malingering on somebody that you're seeing in psychotherapy. It would blow the therapeutic relationship right out the window. And finally, there are very, very different rules regarding privileged communication. As I may have mentioned before, psychotherapy is legally under the heading of psychotherapist patient privilege, which has many, many exceptions to it. If you do forensic work at the request of a defense attorney, you are covered under the attorney-client privilege. So if you mix the roles, which privilege are you acting under? As a case example, which comes up over and over again. Let's say you have failed to separate these, and the person whom you're seeing in therapy and now doing a forensic evaluation on talks about being involved in child abuse. Well, as a clinician, you have a mandatory obligation to report child abuse. Under attorney-client privilege, you do not. So which one of the privileges do you operate under? Let's see, I think, oh, we just talked about this. Media, what to do and what not to do. The basic rule of thumb is try to avoid it as much as possible. You do not, for ethical reasons, want to talk about cases in which you haven't been involved. You don't want to talk about cases in which you have been involved, because you really don't know the limits of informed consent. What can a person, especially if they have a mental disorder, to what extent can they consent to your going public with their case? So the safest thing, don't talk to the media about cases in which you're involved. Don't talk to them about cases in which you are not involved. I have one exception. That's when something has been going on in the media that represents a real distortion of what psychology can do. So I feel it's an educational task. I'll give you a quick example. I was involved in a case many years ago where the defense was saying that an elderly African-American male who shot into a crowd of kids who had been throwing rocks at his apartment. He thought he was firing into the air. One of the bullets ricocheted off of a wall, killed one of the kids. He was charged with manslaughter. The defense expert said that this guy was suffering from urban fear syndrome. I got a request from one of the TV stations to comment on whether or not there was such a thing as urban fear syndrome. And so I discussed very briefly, I think my time in front of the camera was about 30 seconds, that there is no such thing as urban fear syndrome. Okay, I see we're coming to the end, so why don't I end up on this issue about psychological assessment. Hi, Jeff. And that is matters dealing with release of raw psychological test data and release of test materials. Now, this has changed. Up until 2002, we had a standard that said that you released raw psychological test data only to people qualified to interpret it. Under HIPAA, that resulted in significant changes, which is that a client or patient can request their raw data. They can request that you turn it over to anybody of their choosing. So what happens when you have stuff that you need to protect? I was involved in a task force from Division 42 where we put in a kick-out clause, and this might be interesting for some discussion, Jeff, because I know you disagree with me on this point, is that if you feel as a clinician that release of that raw data could either harm the individual or result in misuse of the data, you can try. You may not be successful. You can try to withhold it. Recognizing that the ultimate decision may be made in terms of HIPAA regulations, but at least you try. The other thing to keep in mind, this has to do with the raw psychological test data itself, which is regarded as coming under HIPAA because it is part of the patient, part of the client being revealed. It's what's called protected health information. This is different from test materials. Test materials are the actual test questions, the answer sheets, things of this sort. You're under no obligation to reveal that, even though a subpoena may say turn over everything. The only thing conceivably that you would have to turn over are the answers, not the actual test questions. Okay, I think I'm going to stop here. I had some other comments about sexual involvement with clients, but I think that's only quasi-forensic. So thank you all.
Thank you, David. We have a few questions for you. For those of you who need to ring off, you still have 5 minutes and then you can ring off. David has agreed to stay on and answer the questions until we've exhausted them. And now they've increased from 6 to 8, so we have now more questions. So we have a question here regarding something you said at the beginning of your presentation, David. If the defense does not use you, paren, your report is not favorable to their position, close paren, but the state wants to, when they find out about your opinion, are you allowed to testify, or do you need the defendant's consent?
First of all, that's true only in a small handful of states. The vast majority of states say that it is protected under privilege. So the answer is this would apply only in a few states where they do have the state having the right to subpoena you. It might be helpful, to get consent, but there's really no need to. The chances are the law in the state says the state is entitled to it. They'll be able to get it.
Wouldn't they have to prove to you that they had a right of access to the data? I mean, I would suggest to people who had a question about this that they should make the state produce that statute or that regulation that allows them to do that before you would ever do it. Would you agree with that?
I would agree, but the way the law is written in those states, and the ones off the top of my head, New York, Ohio, Missouri, Washington State, Alaska, those are the ones that come to mind. It's written right into that something where the expert witness's response is not favorable to the defense if they're hired by the defense, then the state is entitled to open discovery.
But this is related then, in those states where a psychologist could be forced to switch sides and testify for the other side, why is he or she not protected by legal, and ethical confidentiality standards to the original attorney who hired him or her as a consultant? My understanding is that attorneys are almost never allowed to switch sides.
Well, it's not the attorney who's switching the side. The attorney who retained you is the defense attorney who says all of this stuff comes under attorney-client privilege, don't release it. And then it's the state that is coming back and saying, our state law says, that if the defense is putting forward an insanity defense without a witness whom they had originally hired, then the state is entitled to know what that witness found. I'm not sure I'm answering the question, but it's just the way the law is written. I direct you, the case in New York State is a case called Edney, E-D-N-E-Y, Edney versus State. I think that was the very first one that came up along those lines. But, you could say, I can't thing except with authorization of the client or the attorney. You could try, but I don't think it would get you very far.
Well, even if you didn't, I mean, would you think it would be wrong to wait for the trier of fact or the court to order you to do it so you make sure that you're not making a mistake?
No, no, that would be fine. That would be fine.
Okay, I'm the old risk manager, you know. I don't like psychologists practicing law. People yell at me all the time about doing that. So anyway, question, Thomas Saz in his book, The Ethics of Psychoanalysis, spoke of contractual concepts involving clinician and patient in autonomous psychotherapy. I think he touched on some of the facets regarding privilege you alluded to in your discussion. Any impression of his work?
Well, I have to admit, it is many, many, many years ago that I read Thomas Saz. And I think he makes a lot of good points, but I think he sees the entire issue in terms of society imposing values on an individual rather than an individual who, for their own subjective hurting, is seeking out psychotherapy. But I'm not really sure, about the context within the forensic. I'm not sure what the question is asking.
Okay. We want to remind people who want to ring off now, they can. And I think that Rachel has posted the link to the continuing ed or to the CE certificate.
Yep.
For those of you. Say again, Rachel?
It's in the chat, the eval link.
Okay, so we'll go ahead and knock these last questions out. To my knowledge, there are very few, if any, tests that have been validated on pre-trial forensic populations. Is there particular language you recommend including in a report to acknowledge when tests have not been validated on pre-trial forensic populations?
Yeah, I would say that, I would say that while a particular profile shows elevations on X, Y, and Z, and basically you have to go back and do a content analysis for this, one needs to consider whether or not the situation, the context has had to do with the items. Now, what I used to do was to always go back and inquire about those items to see whether or not they were context related. So if they said, sure, the officers tell me when to go in and out of my cell, while I don't take that out of the scoring, I say, that would explain a seemingly paranoid sounding item. So it's much more of an article by article kind of thing. I did many years ago generate with several other colleagues a list of what we called forensic critical items and sent them to Alex Caldwell, who I do not believe is still alive, but his Caldwell report persists, and I don't know whether they still have the supplemental forensic report, but it will highlight those items that were endorsed that could have different meanings within a forensic setting. And then you can go back and inquire on those items.
Okay. I apologize, the ringing is coming in on my computer by downloads, but I can't shut that off and continue to talk with you. So I'll have to weather that. My apologies. Great and comprehensive webinar. In your discussion of ethics and forensic perspective, question has to do with what about a psychologist who is not a member of APA and possibly then not sanctionable? History of psychologists involved in torture, etc. Thoughts or expansion of ethics and application of ethics?
Well, if they're not a member of APA, obvious APA can't do anything. But if they are doing psychological work in a particular state, I would imagine they had to be licensed. So that could go to the state licensing board.
Yeah, if I could to say, I mean, APA has moved away from actually doing disciplinary actions
Right.
and has left them up to the states because they have much more money and the ability to go after individuals in a much more comprehensive way than a professional organization could do. So the code is cited as regulatory in most of the states, and many states it's actually written into the licensing law. So
Yeah, that's right. That's right. Yeah, but there was something about the torture. I don't know.
I think that just with the individuals getting away with violating the code, that APA can't sanction them because they're not members and they have committed torture or other
Yeah,
or
well,
unethical conduct.
as we well know, that that was the issue with the two individuals who were found. One of them was not even a member of APA. The second one, my understanding is that when he got wind of the fact that there was a possible ethics complaint coming down the road, he withdrew from APA.
Right.
I think that's the correct time frame. And then that gets into the whole issue, which when Dr. Younggren and I were on the ethics committee, is can somebody resign while under investigation? And I know we had a discussion, for a while, yes, then again, no, then again, yes. And I honestly don't know what it is right now because it keeps flipping.
It ended up that the association can maintain your membership if you are under investigation. Before, they couldn't do that. And so somebody could resign. I think that's a change from the 90s to the early, something around 26 or 20, something in terms of that era. Here's a good one. They're all good, but this is, if you have been seeing a client for psychotherapy and the person's lawyer asks you to write a report or testify on the person's behalf, which you will do with the client's consent, how does privilege change, if it does, now that you are working at the request of the person's lawyer?
Well, the lawyer has asked you for the report. You've got the consent of the client. So you've got both. You've got the consent of the client, and the attorney has the choice of whether or not to use that, or whether or not, the attorney says, no, this has got some stuff in it. Let's just keep that buried under the privilege. So you're protected both ways.
Yeah, but I think that they're talking about you're actually a treating therapist being asked to write a report for the attorney and testify in a forensic proceeding.
Okay, in a forensic proceeding. Then you should not get into any of the forensic issues. You can testify, but not about the forensic issues. You can testify about your diagnosis, your treatment, your prognosis, but you cannot testify about, say, competency or child custody or parenting capability or proximate cause of an accident or injury. Those are all forensic issues which require a forensic assessment. So yes, you can testify as a therapist, but it's very limited as to what you can testify to.
Okay, one last question, David. Any thoughts about functioning both as a trial consultant and an expert witness role in the same case?
Yeah, there are some people who say that, it's a multiple relationship, that you have to separate the two very strictly. I don't really believe that it's quite that clear cut, because when you are doing an evaluation, part of the materials you're looking at are somebody else's evaluation. See how yours compares, see whether or not the other evaluation was done under the same circumstances. So essentially, you're serving both roles at the time that you do the evaluation. So, while I wouldn't formally be a trial consultant, I think that you're probably doing some of it anyway when you do an evaluation.
Okay, and one other question came in, David, I think needs an answer here.
Sure.
Please clarify raw data. A true false MMPI, would true false, the answer sheet with true false circles seems to be raw data. Waste protocol with the respondent's answers also compromised. Test materials, given that the test questions stimuli are on the test protocols. Thus, would the waste 4 protocol be considered raw test data or test materials?
Well, that's a great question. And Jeff, you know from the book that you and the rest of the folks wrote, Eric and Bruce and everything, they had a very, very nice suggestion on that. They said, yes, you've got both raw data and test materials. So when you get such a request, you just put together on a computer what the answers are. You say like comprehension, item number 1, put it in the mailbox. Item number 2, so they'll taste better and won't make you sick. But you don't put the actual questions on. That at least was the suggestion from the book. Correct me if I'm wrong, Jeff.
No, I think that's correct, that you sanitize it so that they have a right to the answers, but they do not have a right to the questions.
Exactly.
Also, people like to ask about, well, can I bill for that time that I have to do that for someone? And that should be in your informed consent.
Yeah.
Exactly. That all of that stuff needs to be clarified before you even engage in the relationship with the person you're evaluating.
Right.
Because you should be compensated for it.
Sure. Yeah, I didn't get a chance to talk about fees, but there are a lot of ethical issues having to do with fees, and not accepting contingent fees,
Yes.
and things of that sort, but beyond the scope right now.
Yeah, we've really kind of exhausted it. David, as always, it's great to see you. The University of New Mexico appreciates your contribution. We know that you've made time to do this and did it on short notice for us. And you had like well over 400 people listening to you today.
Wow.
So
Thank you.
Good showing, David. Rachel, do you have some things you need to say?
Nope, other than just to remind everybody that the evaluation link is in the chat box. And if you're having any issues, you can let us know. Me and Anthony will stay on a couple more minutes. Otherwise, thanks for presenting, David. It was great.
Okay, my pleasure. I enjoyed it.
Thank you, David. Always good to see you.
Always great to see you. Okay. I would say I'd see you at APA, but maybe not maybe next year.
Next year for sure.
Okay.
Thanks a lot.
Take care. You're welcome. Bye.
Thanks, Jeff. See you next week.
Okay. Bye-bye.
Bye.
Okay, folks, I'm going to stay on for 2 more minutes. If you have any help regarding the CE evaluation link, please submit them in the Q&A. Other than that, have a good rest of your day. I saw the question regarding the question live. The question regarding the PowerPoint, it will be emailed at a later date. I will reattach the CE link in the chat. Here we are. Hi, Mary. I'm going to attach the the link into the evaluation in the chat real quick.
That's good too.